Good afternoon, everyone. My name is Sophie Campbell. I'm a Commercial Litigation Associate with CMS and a member of the SYLA committee. I'm delighted to be chairing the next in our widely attended From Precognition to Proof series, where today we will be lending our focus to motions. Throughout the session, we would encourage you to post questions into the chat box, or alternatively, there will be some time for Q&A at the end if you wish to pose your question to Robert directly. There are no silly questions here. We're all here to learn, and I can guarantee that if you pose a question, someone else in the audience will be grateful that you did so. Today's session will be delivered by Robert Hovey of Themis Advocates. Robert called to the bar in 2020, before which Robert trained at one of Scotland's leading litigation firms, gaining experience in a wide range of personal injury cases, including road traffic accidents, employers' liability, public liability, and industrial disease. He also has experience of professional liability, fatal accident inquiries, and criminal law, particularly offences arising from road traffic accidents. Whilst Devling, he built upon his experience in these areas, as well as gaining exposure to clinical negligence, foreign travel claims, and claims arising from accidents abroad. Robert also won the Mike Jones Excellence in Advocacy Prize. And now I will pass over to you, Robert.
Oh, thank you, Sophie. I think that marketing is maybe slightly overpitched in terms of a CV, but thank you very much. Well, good afternoon, everyone. I'm absolutely delighted to be here to talk to you all about motions. When I was preparing for this, I tried to have a think about what perhaps we should discuss. And what I did was reflect upon the times that I have been in court over the years, whether that's sitting in court waiting to see if your proof is going to go ahead, or sitting in a long call over waiting for your motion to call. And I've reflected upon instances where I've witnessed people get into difficulties or say things that have irritated the bench, and I've structured this session on essentially just a lot of takeaway points, short, sharp points that I have taken away and applied in practice. And I think if everybody at least walks away with at least one or two of those takeaways, and that does some good, then I think that's been a successful outcome. So hopefully everyone can see a PowerPoint on their screen. It is an atrocious PowerPoint, so those that were expecting fancy videos and animations of flying in, apologies in advance for that, because you're not going to get it. But hopefully it's now turned to an introduction. So roughly what we're going to discuss is, first of all, purpose of motion hearings. But I think what we'll discuss over the next hour can pretty much be applied to any time you find yourself in court for a substantive matter. We'll talk about preparation for the hearing, which includes just the motion and opposition itself, and the relationship between written and oral advocacy. We will talk about the hearing, the motion hearing itself. I've got some general advocacy tips, a discussion on expenses, and then I suppose I've got tips at the end. Now, tips at the end is not asking for money. Tips at the end, I suppose, is just general do's and don'ts, things that I've picked up along the way. So, starting with the purpose of motion hearing, why am I here? This is a very good question. More often than not, it's because there's a disagreement between parties. You're disagreeing about procedure, or there's no real disagreement about the procedure, but your opponent disputes that what you're seeking is justified. An example of that, I suppose, from my background, could be variations of timetables, discharging of a proof. Tactical oppositions as well. Examples could include motions for sanction, disapplication of quocs, and you may also find yourself in court on an unopposed motion. And I suppose that if you do, you really start to ask yourself the chap in the cartoon of, well, why am I here? There's a few reasons why you can find yourself in court on an unopposed motion. One is because it may have been opposed, that opposition has been dropped, but it's too late in the day for the motion to be dealt with administratively. Equally, the court is perfectly entitled, even on an unopposed motion, to demand appearance from parties, and quite often that is the case. So those from experience are the typical reasons you find yourself at a motions hearing. And unsurprisingly, the thrust of this next hour is on preparation. I was going to include the fail to prepare, prepare to fail, and all of that nonsense, but I think that is applicable. The amount of preparation you do, from experience, has a number of outcomes. One, you're more likely to get a positive outcome if you prepared in advance. You're also going to be more confident. Quite often I see people in court that really are struggling with their confidence in court, particularly at a very early stage in your career. I remember when I first started to appear when I was a trainee solicitor, and find yourself hopping along to Edinburgh Sheriff Court on a Monday morning. It was absolutely terrifying. But if you know what you're going to say and you've preempted some of the questions that may be asked, it does give you a lot more confidence. So there are a number of aspects of preparation I want to touch upon. First is the motion or the opposition you're drafting. Second is what I'm going to call negotiating. And then I've got written and outline and oral submissions. And then list of authorities and an appendix. So turning first to the motion, this is the very first thing the court and your opponent is going to read. I cannot stress how important the drafting of the motion is, because you may well get the court on your side before you've even got to your feet. You also may influence your opponent's decision to oppose. Now, it goes without saying that your motion should state what you want. And what I would say is, if you're asking for a number of things, try to break that down into numbered points. But more importantly, and what I see frequently an absence of, is a justification for the motion, where motions simply state, I want this, but there's no justification of why the court should give it to you. Excuse me. Now, I'm not saying you should have written submissions on a motion and present the court with a 5 A4 page motion. But what you should do is provide the court with the bones of the argument. Now, you will get a chance to add meat to the bone later. And I would suggest that your justification is no more than around half a page. And sometimes, if you think of it this way, is if you were to justify your motion to a family member, ideally a family member that isn't a legal practitioner, and you were to try to do this in under a minute, how would you do that? How do you phrase your justification in half a page in under a minute? Now, that should be the sort of thing that I think should be in motions. Avoid at all costs copying and pasting. Quite often, the court is faced with motions that the justification for the motion is identical because the firm has a standard script. Now, that's all fine and well if the script is up to date and relevant and has a history of going down well in court. But if the script is now massively out of date and repeatedly in the past has not been adopted well by the court, then I suggest that is removed. It suggests a lack of effort. And I was in court on Monday, and certainly there was a motion that was a copy and paste. The court could have told me what the motion said without actually reading it. They just knew what the motion would be from the agent that had enrolled it. And the sheriff was particularly offended by that. So tailor motions to the case. Finally, have someone read over it before you fire it off. The benefit to the practice you are all in is you have supervisors. There is always going to be somebody above you that can have a read over it, give you some points before you send it off. Now, the opposition. Read the motion. It is astounding how many times that I read an opposition that actually has no relevance to the motion whatsoever. So read the motion very carefully before you oppose it. And also think, should this be opposed? Don't just oppose things for the sake of being difficult. What's the benefit to your client by opposing? But that said, sometimes we all don't have times to consider a motion immediately, and you may need to lodge protective opposition to give you a little bit of wriggle room to consider, or indeed negotiate before you get that far. So that is the motion and opposition. And I mentioned negotiate, which takes me to my next topic. The court expects us to work together to try to resolve disputes without taking up the court time. It sounds very simple, but it's quite often not done. Pick up the phone. More often than not, you'll have counsel instructed at a post-motion hearing where you'll hear the phrase, "My lord, I've had the opportunity to speak to my learned friend before the case called," because that's quite often how faculty operates. It is, we'll pick up the phone at the back of 9 and have a chat with our opponent in advance to see, right, look, what's the real issue? Right, look, what's the real issue? So find out what the real issue is, because if you can pick up the phone and sort it out with your opponent, the motion can then proceed unopposed. Now, what's the benefit to that? Well, it doesn't need to call. It saves everybody time and it saves everyone money. Procedural courts at the moment are exceptionally busy, and it's not uncommon to join WebEx or attend in person, and you spend 2 to 3 hours in the world's longest call over before you're 10 minutes on your feet. And that's an extortionate amount of time for practitioners that are very, very busy. Now, if you're going to do this, ideally do it in advance. And that allows the court to deal with the motion administratively. But as I say, if you can't do that, and I appreciate the pressure of time, it's not always possible, at the very least, pick up the phone and chat to your opponent before the motion calls. The court will appreciate it if you use that phrase, "I've had a discussion with my friend or my learned friend," prior to the case calling. Now, written submissions. I would say this is probably one of the areas that causes practitioners most problems. And it's because it's still, I think, quite a new thing for us, particularly those with more experience have grown up with oral submissions, and written submissions are becoming more and more requested by the court, and indeed well received by the court. So what should written submissions be? Well, they should be considered, well drafted, and it should be a professional document. It is a document that the court is going to see. It should contain everything, absolutely everything you intend to say to the court. It should have paragraph numbering. Now, the structure of written submissions is pretty much identical to how you would present the motion if you were just to do it orally. And I've put 6 broad chapters of how I would structure written submissions, or indeed, if I were doing it on the fly, I would still use the following 6. Number 1, what is the motion? Number 2, provide a brief background. Number 3, highlight to the court what is the applicable law in these circumstances. 4, what are the relevant facts? 5, your submissions, and that is applying the 2 foregoing. What is applying the law to the facts? And then 6 is a conclusion and renew your motion. I would say that's generally the 6 points that I cover in every written submission that I draft, or oral submission that I present to the court. Outline submissions. Outline submissions are rare. I tend to find they're actually very effective. Outline submissions are essentially a skeletal structure with no flesh or meat on the bone. It's just the skeleton of your argument. So what would you include on outline submissions? Well, number 1, you include the motion. So the court has the motion right in front of it. Number 2, what are the legal propositions that you are relying upon? So your written submission may contain a detailed analysis of a particular authority, what is said from the authority, copy and paste particular paragraphs from the authority, a discussion of the authority. Your outline submission just has a short, sharp legal proposition that you take from the authority itself. The next would be factual propositions. So what are the factual propositions that you say? And again, this would be discussed in far more detail in written submissions, but in the outline submissions, it can just be short, sharp, bullet point facts. 4, what are the points? Combining the legal and the factual, what are the points you wish to make to the court in submissions? Outline submissions are also a really good place for a chronology. If you're not lodging a separate one, if you want to just incorporate a chronology, an outline submission is really useful. Oral submissions is pretty much what it says in the tin. It's no reliance on written work, other than relying on the motion or the opposition that you have in process. Now, the fundamental question, how do you choose? And that can be quite difficult. How do you choose in advance of your motion to lodge written submissions, lodge outline submissions, or just lodge nothing apart from your motion and just deal with it orally in court? From experience, there's a few factors. One is time. Full written submissions are obviously the longest to prepare. Outline submissions can be relatively brief. So depending on how much time you can dedicate to this, complexity is another factor. If the law you're about to argue is dead straightforward, or the test is very well known, the facts are straightforward, it may be that everything is near enough contained in your motion. So in that case, perhaps you don't need lengthy written submissions. You might consider outline submissions, so just short, sharp points, providing a structure. However, if your motion is particularly complex, written submissions provide the court something to read in advance. It saves the court excessive note-taking. And there's a risk there that something might be missed. The bench varies and depending on how quickly it can take notes. Some sheriffs still use a pen, some are like me, two-finger typists, and some can type furiously. If you've got an important motion and important things to say, you cannot risk that the court misses to note something or misses the importance of something. So written submissions are quite useful to make sure the court has all of the information in advance. Excuse me. The third factor, I think, is your court. Know your court. Does your court have time to consider full written submissions? Now, the frequent court I appear for is the personal injury court. I'm fairly confident now that if I lodge full written submissions before midday on a Friday, the sheriff, whichever sheriff is going to be on Monday morning, will have read those written submissions. Certain local courts I've appeared in, exceptionally busy, and there just hasn't had time to read your written submissions, or at least read them enough times to actually get the point. So know your court. Will the bench have enough time to read your written submissions in advance, or if you've got doubt of that, really should you just lodge outline submissions and be expanding upon it in oral submissions? So next point is authorities. I would say before you lodge your list of authorities, have a good think about, do you actually need to provide it? Are you advancing a legal proposition that the court might be unfamiliar with? There is a surefire way to irritate the bench, and that is to provide a big list of authorities, no passages highlighted whatsoever, no clear relevance to what the authorities are. There's been no submissions provided to the court in advance, so the court has no idea what you're taking from those authorities. Because the only thing the court can do is just read every single word in advance. If your case then calls and you don't refer to your list of authorities at all, that may irritate the bench somewhat. Also, if you're lodging an authority that the court is incredibly familiar with, Again, you may irritate the bench by taking the court through law that it is more than familiar with. But here comes the tricky question. Is it safe to presume the court is familiar with? No, it's not. You don't want to be the person in court that says, well, I trust my lord is familiar with Smith v. Jones, for the sheriff to then say, well, actually, I've never heard of that before, and be slightly embarrassed. So if you are in doubt as to whether an authority that you think you may need to rely on is known to the court, if in doubt, lodge it. You can always canvass with the court whether the court wishes you to take the court through the authorities. The court can then save face if the court does not know the authorities and say, yes, please do. Or the court can say, no, it's perfectly fine. I know this case. And believe you've lodged it in advance. The final point, if you're going to do that, highlight the passages you intend to rely upon. If you're only relying on one paragraph in a 40-page decision, highlight it in advance. The court will appreciate that. The next thing I've got is appendix, and this is something that's used quite rarely, and I'm not sure why. In your motion, have a think about whether there's any documents the court might need to refer to. For example, the record, any particular productions that have been lodged in process, or a chronology. The court uses online systems now, and despite it being a good few years, certain courts still can't seem to find anything online. And that seems to understandably cause sheriffs quite a degree of annoyance when you can see them searching furiously through a computer, but they can't find something in ICMS or whatever it's called. So if there's a particular document, prepare an appendix. If you're arguing in relation to, for example, certification of an expert, prepare an appendix with the record and the expert's report, because at least the court will have that before them quite easily. Again, you can highlight averments on record, passages of the report, and it will allow you to, again, take the court to particular pages, particular averments or passages very, very quickly. Because remember, this is all about you presenting to the court. You don't want to lose the court with the court desperately trying to find documents if you just prepare everything and just help the court follow you. I've put in bold here, remember, it all needs providing in advance of the hearing. Try to avoid as much as possible sending lots of items to the court the morning or the day before a motions hearing, because again, you're most likely to find the court saying, well, no, Mr. Hobie, I've not read your written submissions because you actually only emailed it to the Sheriff Clerk 20 minutes ago. So hopefully that is preparation. And I suppose the point to take from that is, I suppose it is the preparing to fail, or failing to prepare is preparing to fail. It's all about preparation. Think about whether written or outline submissions is going to assist your case. Think about authorities, think about appendices, think about your motion and opposition. The next part is the hearing itself. And I just thought this was funny, so I've put this in. Get some of those glasses Homer has when he looks awake, but he's actually asleep. That's really good. Just don't wear them and actually fall asleep. It causes problems. Now, the hearing itself. So I've got preparation. I'm sounding like a broken record. So preparation again. This is the basics. Know the date, time, and the format. Most of my procedural hearings are now by WebEx. I anticipate that might be the same for a lot of people, but we do still get procedural in-person hearings. There's nothing perhaps a little bit more stressful than at 9 o'clock in the morning chasing someone for the WebEx link only to find that you're actually meant to be in Kirkcaldy in person. Not that that's ever happened to me, or I won't admit it anyway. So check, are you in person or by WebEx? Do you have the link? If you've got a link, join well in advance. If you join 15 minutes in advance of a WebEx hearing, everything works perfectly. If you join 2 minutes before a WebEx hearing, everything breaks down and your camera doesn't work or your microphone doesn't work. It's just guaranteed sod's law. So join well in advance. Don't be afraid to ask the clerk if you can check your audio and video. There's nothing wrong with that. That's the point of joining 15 minutes early, is you can say to the sheriff clerk, you know, can you see, can you hear me? For those that don't know the consequences of when that goes wrong, please YouTube I'm Not a Cat for an American example of when it all goes Pete Tong. So always check the audio and the video. Don't be the cat. Dress appropriately. I'm surprised that I say that, but I actually do see quite often, particularly on WebEx, it tends to be the gents, unfortunately, with the shirt and tie but no jacket. It is cringeworthy to see somebody in court with a shirt and a jacket, a shirt and tie but no jacket. Business dress, it must be business dress. I'm also embarrassed to say, make sure you're dressing appropriately to your lower half. There is a horrific story that came out last year of a legal practitioner, and I've never got to the bottom of who it was, that the court said, can you stand up on WebEx? And the practitioner was wearing something on the lower half that was deemed inappropriate. I dread to think what it was, and I'll leave it to your imaginations, but remember to dress professionally, both half, lower and top, even if the court is only going to see the top half of you. So preparation. Waiting is brutal, yes, I appreciate that. Courts are very busy, sitting for hours on end, conscious of the other work that you've got on your desk to do, and you're just waiting on your case to call, can be brutal. But I would suggest you think of it as a learning experience. Many things can be learned by watching other people, whether it's something they do good or it's a mistake that someone else makes, embarrasses themselves, but you learn from that so you don't make that mistake. So listen and learn from others during your call-overs. It's also important to listen to see if the court has a similar issue before it. I once sat through a call-over, and there were 4 cases about reponing notes, and all 4 representatives took the court through the exact same submission for the test for a reponing note. The court sat there, and in fairness to the sheriff, he was actually very patient, and he sat there and listened 4 times to the exact same test being narrated. The point to take from that is, if you are the 5th case to call for a reponing note, don't be the 5th person to take the court through the test. If you've listened and you're happy that the legal test has been explained properly and the court understands, it's safe to say you can skip that bit, and you'll probably gain a bit of favour from the bench for doing so. Listening during the call over, you also get a feel for the sheriff as well. Does he or she like to be kept to the point? Is this a court that is quite happy just to hand over the microphone to you and let you speak for as long as you need to until you finish? Are you likely to get interrupted with questions? Or does the sheriff seem to like it kept to the point? You can get a feel for the sheriff if you're later on in the call over, and you can tailor your submissions accordingly. We were always told to watch the pen. By WebEx, you can't see the pen, so you get a feel for the sheriff. What's their indication? Do they nod? Do they grunt? Do they look up? What's the indication that they've taken on board what you're saying and you're good to move on? Third point is introduction. Remember, in the sheriff court, it's okay to say good morning. For some reason, you can't say that in the court of session, but in the sheriff court, you can say good morning, good afternoon. I always suggest you start with that. It's a very pleasant way to start an introduction. It's good morning, my lord. Good morning, my lady. Introduce yourself and introduce your opponent. Again, it's just a matter of manners. If you're the person leading, it's your motion, you should go first. Introduce yourself, introduce your opponent. Fourth point, this is where you are presenting your motion without the benefit of any sort of written aid. So it's oral submissions only. And I'll go through this. I'm going through this first because, as I say, this, I suppose, is the same structure you would use for written submissions. So the first point for oral submissions, number one, is the motion. My lord, my lady, will see this calls for the pursuers or the defender's motion for X. It's opposed in full or it's opposed in respect of Y. So highlight to the court, what is the motion? It is opposed, obviously, but what is it opposed in respect of? The discharge of proof, my lady, is not opposed. We are here to discuss expenses. So highlight to the court what the scope of the dispute is.
God, for fuck's sake.
Okay, that brings me on to my next point. Always make sure that you're muted when discussing if you do find yourself in court. So that's your motion. Two, your background, using the phrase by way of background. What kind of action is it? What type of the procedure is it? Think first, though, if that's necessary. If you're in the All Scotland Personal Injury Court, you probably don't need to advise the court that it's a personal injury action. But if you're in a local court that has a variety of actions before it daily, advise the court, what is the type of procedure? What kind of action is it? Explain what this case is about in a few sentences. And again, this is explaining to your granny in under a minute. It's short, sharp, and simple, just to give the court a heads up of what the case is about. Three, the applicable law. I mentioned a moment ago, how do you know whether the court knows the applicable law? It's not worth taking the risk. So whether you lodge written submissions or not, sorry, list of authorities or not, simply say, would it assist the court, or would it assist if I take the court through the applicable law or legal test to be applied? You've handed the ball to the court. It's a nice, polite way of saying, does the court understand? Does the court want me to walk it through it? And you'll just get a yes or a no. It's a nice, easy way. If you get a no, Mr. Hovey, I'm perfectly familiar with this test, move on. If it's yes, please, Mr. Hovey, take me through the authorities, then that's fine. Take the court to the authority. So, my lord, if my lord can have before it number one on the list of authority, Smith v. Jones. Court then turns to the authority. Explain to the court why you are taking the court to the authority, because the court will want to know, why am I looking at this? So just explain, my lord, Smith v. Jones, I say this establishes this particular test, or whatever the test is to be applied. This is what I say establishes the test. Take the court to, hopefully, your pre-highlighted paragraphs and walk the court through it. My lord will see from page, paragraph number, there's a highlighted paragraph. Does my lord, does my lady have that? Check they're with you, because if they're not, then everything you say thereafter is pointless. Check the court is with you. Take the court through the paragraph, read it to the court, and then state the legal proposition that you say the court should take from that. I would say that is an effective way of using a particular authority. Take the court to the authority. This is why I've got this in front of you, my lord. This is what it says. And this is what I say the court can take from that. After the applicable law, earlier on I mentioned the facts. This is when a chronology comes in handy. If you're arguing something that you need a timeline for, you can help the court with a chronology. Bearing in mind, again, if you're going to take the court through the procedural history, the court's going to have to write this down unless you provide a chronology. Whatever the facts you're referring the court, keep it brief and keep it relevant. Keep asking yourself, why am I saying this? What is the point of this to this motion? Now, if you write down some facts and you can't answer that question, there's a good chance that it's irrelevant. So take a step back and think, why are these facts? Why is what I'm telling the court relevant to the specific motion the court is being asked to determine. And then that takes you to your submissions. Now, you've already highlighted the legal propositions, so the law that you say the court needs to apply, and you've highlighted the factual propositions, the facts that you say the court should accept and apply to the applicable law. Bring them together. Explain to the court in submissions how applying the law to the facts you say the motion should be granted or refused. Finally, end with a conclusion. It should be a one-paragraph summary, no more. Short and simple. It's the very last thing the court is going to hear, and it might be the last chance you get to speak. So make sure it's short and it's punchy and it brings everything together. And then finally, renew the motion you're asking the court for. And if you're struggling with an end, the classic phrase of, unless I can assist the court further, those are my submissions. That's usually the easiest way to bring an awkward silence to a close. Now, that is the same structure I would have with written submissions, but how do you present your opposed motion hearing if you've lodged written or outlined submissions in advance? So what I would suggest with written submissions, has my lord or my lady had an opportunity, so you do your introduction, has my lord or my lady had an opportunity to consider the written submissions? Now, if you get a yes, now, if you are of the view that the court, knowing your court, will have time to consider those written submissions, and chances are the answer will be yes, I have. All you need to do is adopt your submissions. So, good morning, my lady. Hobie for the pursuer, Smith for the defender. This is a chapter 36 personal injury action. Has my lady had an opportunity to consider the written submissions for the pursuer? Yes, I have, Mr. Hobie. Much obliged, my lady. Can I simply adopt my submissions this morning? That's it. Your written argument is now the argument you've presented to the court. You can add a few more comments. For example, if your opponent has also lodged written submissions, I would say, well, my lady, I would simply adopt my written submissions this morning and keep my oral submissions restricted to comments on the defender's written submissions. Or if your opponent hasn't lodged written submissions, you could simply just say, my lady, I'll adopt my written submissions, but may need to address the court further following my friend's submissions. So you've given yourself a little avenue to come back again once your opponent said their piece to make a few comments. I'll reiterate this when I come to the top tips, but do not, under any circumstances, read verbatim written submissions. There is nothing more brutal to watch than someone that reads, that watching the court and the practitioner read verbatim 10 pages of written submissions. You will be hard pressed to get a bench that patient that will allow you to do that. You do risk the sarcastic comment of, well, Mr. Hobie, I can read. I don't need a bedtime story. I can read, Mr. Hobie. So do not read verbatim written submissions. That's why you've adopted them. Outline submissions. You start in the same way. Has my lord and my lady a copy of the outline submissions? Yes. Now, in this case, you will use the outline submissions because you're expanding on essentially a skeletal argument. And the way you do it is, if your outline submissions are all in paragraph numbers, as they should be, you just say, my lord, my lady, can I take you to paragraph 1, 2.5, etc. My lady will see the pursuer's position or defender's position is this, or take my lady to paragraph 5. My lady will see here that I say this. Again, the outline submissions may state just the legal proposition you want the court to take. But in oral submissions, what you're going to need to do is take the court to the authority and then discuss the authority with the court orally, having set up the outline submission and the legal proposition on paper. Same with the factual propositions. The outline submission may have 4 or 5 written numbered factual propositions, but you will take the court in oral submissions to documents like the record or productions, etc., or chronology to expand upon that. It is I find quite useful if you're short on time, not confident the court will have an opportunity to read lengthy written submissions. You can use it essentially as holding the court's hand and taking the court through your outline submissions. If there's any points in your submissions you think are absolutely essential that the court understands, then those few points might be worth having written down. Everything else you can expand upon. So that is the hearing. Now, that says expenses, but I've got one chapter to cover before that. Advocacy tips. Vary your tone. Points can be emphasized if the volume is increased. That's one way of doing it, or by repetition. So by repetition. Now, how do you do that if you're using written advocacy? Underlining. So what I will often do if I've got outline submissions or anything I'm expanding upon, I'll put them in bold or underline, and I know that this is a particular sentence or a particular word that I want to emphasize to the court. And then when I'm reading from that or expanding upon that, I will know that that's something that I need to emphasize. So that's a good tip. As always, keep it slow. I've got watch the pen. You can't watch the pen, but watch the head. Listen for the grunt. Keep it slow. Don't be afraid to pause. And I see this quite a lot where people are desperate to fill silences. There's nothing wrong with silence. Obviously, you can get too far to the other end where it becomes a ridiculously long silence, and you probably need to do something at that point. But don't be afraid to pause. Pause helps two things. Pausing can give you a moment to think. Excuse me. Pausing can give you a moment to think. It's another example of repetition. Or pause can be quite effective for an emphasis. So if you've got a particular sentence you're reading to the court or you're saying to the court, and there is an aspect of that that you really want to emphasize, stop a few words short and pause, because you're likely to get the sheriff's head to lift up, pay attention a little bit more, and they will catch that point. So don't be afraid to pause. Now, if you're going to pause, if it's a long pause, and I leave it to you to decide whether it's a long pause, ask the court for a moment. So a few seconds, that's fine. But if you need a couple of minutes to gather your thoughts, probably best just to say to the court, my lord bears with me for a few moments, or my lord allows me a moment. You'll never be refused. So if you need time, ask for time. Remember, it's my lord, my lady, your lordship, your ladyship, not my lordship, not my ladyship. Never use you. Do you see this? Please, please, for the love of God, don't do that. My lord, my lady. But avoid repetition. We don't need to have, sometimes you can sit and listen to a motion and count how many times my lord, my lady, or in my submission is used. Remember that everything you're saying to persuade the court is a submission. You don't need to start every sentence with "in my submission." You might need to say, you can start it once, but thereafter try to keep repetitions of "in my submission, my lady, in my submission." Try to keep it as short as you can. So some general advocacy tips. Expenses, which is sometimes what a lot of them come down to. Prepare submissions for expenses in advance. Most motions are going to go one way or another. You're going to win or you're going to lose. So there's two outcomes. You can prepare what you're going to say in advance for both. Now, expenses usually follow success, but not necessarily. What if the court's decision is a compromise? So court compromises between what you're asking for and what your opponent says you should have something else. What if the terms have been offered, that if your opponent has offered that already, once you picked up the phone in advance of the motion calling? Your opponent can use that to move for expenses, even if they've lost, on the basis that there was no need for this motion to be called because the court has given you something that was already offered. So preempt that. Remember the default. If no one says anything, expenses are in the cause. How does that affect your client's position? Remember, there's no expenses due to or by. Now, that's particularly helpful, I find, if you think expenses are going to be found against you. So you don't think you've got a particularly good argument to say why, even after losing the motion, you should still be given expenses. Give the court a secondary position, an ESTO. ESTO position, no expenses due to or by. What seems to be coming up quite a lot is quox issues, where defenders would normally be entitled to expenses but for quox. In those occasions, you should be moving for expenses to be reserved. Finally, some tips. That's got no relevance. It's just to make you smile. Do's and don'ts. I've already covered. Don't read written submissions. The point of lodging written submissions is, as I said, it's for the court to read them in advance and for you to adopt them that morning. You don't need to read them verbatim. Number 2, don't throw mud. Sitting in court and listening to 2 practitioners throw mud at each other, tit for tat. Well, I appreciate I need to vary the timetable, but he did it before and he didn't respond to my email. It's just embarrassing. We're professionals. Don't throw mud. Be professional no matter what your opponent is doing. You need to have a straight face. You might think in a busy court that no one is watching you. There will be. There is someone watching, always. Sniggering or smiling and smirking when your opponent is saying something is just not on. Even if your opponent is talking absolute rubbish, complete nonsense, keep a straight face. And that's quite often something you see, particularly on WebEx. When someone's got the camera on, doesn't think anyone's looking because there's enough tiles on the screen. Trust me, there is always someone to see the smirk, so don't do it. Something I saw recently, if something happens that's unexpected, you have prepared for your motion. You think you've covered all eventual outcomes questions, but something happens that's unexpected and you don't know what to do. So you turn up in person to find that your opponent's not turned up or a party litigant's not turned up, and you hadn't planned for that. Don't be pressured into just accepting a suggestion from the court. Don't be pressured into agreeing something if you don't have instructions or you didn't come prepared for that, because you have options. If you don't know what to do in those circumstances, you can ask the court to continue the hearing. You just say to the court, my lord, this is unexpected. I need to take instructions and move to continue the hearing a week. I really struggle to find why that would be refused in the circumstances. So don't be afraid to continue the hearing. Equally, don't be afraid to say to the court, my lord, this is unexpected. I need time to consider. I've got a phone call to make. I need to take instructions. Can this case be called again at the end of the rolls? You will always get a yes to that at that request. Leave the court, whether you're leaving by WebEx. If you're staying on WebEx, make sure you mute. Probably best just to leave the vicinity and seek advice from a colleague. But if you're unexpected, don't be pressured into agreeing something. Continue the hearing or ask for your case to call again. This is one that I think applies more towards faculty, but I would say it applies to everyone, I think. Remember, when it comes to an argument you're presenting to court, there's a difference between prospects and stateable. Your argument might be a poor argument. It might have poor prospects, but it must be stateable. It has to be a stateable. We all have a duty to the court, and it must be a stateable argument. Okay, what happens if you get a motion and you're not particularly comfortable with the applicable law? You've never done a motion like this before. Well, obviously, one of the options to you is just to go and ask a colleague. But the other option that I think is sometimes underused is to check the authorities. bear in mind the authorities, cases that have been published, if it's a similar issue that you're about to present, somebody else has already spent hours researching the authorities, the legal arguments. They've prepared their argument, they've taken the time to present it to the court, and you have the court's comment on whether they're talking sense or just talking nonsense. So read that, save yourself some time and see what has been said before. How did that practitioner present the argument? How did it go down? Did it go down well? Did it go down on a Hindenburg? Learn from the mistakes of others. I would suggest, as much as you can, get onto the Scott Court website. Every decision that's published, read it. It's amazing what you can learn from the work of others. The final point I make is a topical one. It's judicial conduct. I think we're now in an age where people are a lot more conscious about bullying in the workplace. And I think we're a lot braver nowadays to say something when we feel that someone has crossed the line, whether that be a solicitor, your opponent is a solicitor, your opponent is an advocate, or indeed the conduct that you're uncomfortable with comes from the bench. It makes no difference. Conduct like that needs to be called out. Now, that said, there is a line. We need to remember that the court is there to test your argument. And sometimes it can feel that the court is giving us a bit of a rough time. But we have to remember the court is there to test an argument. We have a dispute. I say one thing, you say the other. We can't both be right. The court needs to decide, and the court is entitled, and indeed that's the court's role, is to test our arguments. But as I say, it's a fine line. And I'm glad to say I've never been on the receiving end of this, but I am conscious that disapproval with judicial conduct and conduct from opponents, whether solicitors or advocate, is there. And I want to make that entirely clear. You should never be made to feel uncomfortable, bullied, shouted at, or embarrassed when you are in court. I appreciate people get anxious when you're in court. You can be nervous and you can be anxious, but you should never be made to feel uncomfortable, bullied, shouted at, or embarrassed. If that happens, you need to speak out, because not only are you doing yourself a favor, but you're doing every other practitioner a favor, because it's only when these things are called out that do things change. But remember, that said, it is a fine line and the court can test your argument. Now, the line's a difficult line. How do you escape when the court is testing your argument? You feel you're back into a corner, you've said everything you can, you're starting to waffle a little bit. Simple phrase, and it's a get out of jail. I don't think I can develop that argument further. My Lord has my submissions. I don't think I can develop that argument further. That is subtly saying to the court, you've said your point, I've got nothing else to say, can you stop? Can you just stop now? Okay? If you say that phrase, the court will stop. Simple as that. If you can't answer a question, if you find yourself backed up against the wall, use that phrase. And that should bring an end to the matter. But remember, the court is there to test your argument, but there is a line. And if that line is crossed, then you need to speak out. Also, for those that may have children, the annotations on the PowerPoint are probably pretty helpful. Don't do any of those things either. That is the end of everything, of the PowerPoint and everything I wanted to cover with you all.